If you are on an H-1B visa right now, you probably know exactly what this looks like. You spend a decade building a career, paying taxes, and putting down roots, only to wake up one morning and feel temporary all over again. The timeline is the same for thousands of people. You transition from an F1 student visa, you enter the green card backlog, you buy a home, you have children, your entire adult life happens right here in the United States. Then the 2026 tech layoffs hit. The lights go out on your department, and suddenly that decade of investment is in jeopardy. Immigration forums are exploding with the exact same questions. People want to know if they can safely switch employers. They want to know how long the grace period actually is. They want to know if their families are safe. For an American worker, losing a job means losing a paycheck. For an H-1B worker, losing a job is an immediate threat to your legal right to exist in the country where you built your family's history. The panic starts on day one. The moment your employer terminates your position, a legal countdown begins. The U.S. government gives you a maximum 60 days, or until your I-94 expires, to find a new sponsor. If you hit day 61 without a filed transfer petition, you are out of status. Your legal authorization to be in the United States evaporates. The problem is employer dependency. The U.S. immigration system ties your status to a specific company, not to your individual skills or merit. That dependency traps your family too. When the primary earner loses their H-1B status, their spouse and children immediately lose their dependent status. A layoff forces the entire household into a race against the calendar. Your right to stay depends entirely on finding a corporation willing to fast-track complex legal paperwork before the clock runs out. Getting a job offer does not stop the clock. The new employer has to successfully file an H-1B transfer petition with USCIS before those 60 days expire. This flowchart maps out the transfer process, and right here is the biggest roadblock, the request for evidence, or RFE. USCIS can halt the process and demand extra documentation from your new employer. In 2026, USCIS is aggressively scrutinizing remote work compliance and verifying employer locations. This makes RFE delays highly common. This brings up the most heavily debated topic on Reddit right now, international travel. Leaving the country right now with an expiring visa or a pending transfer exposes you to the travel trap. If your paperwork is flagged while you are overseas, you risk being permanently denied re-entry at the border. You end up completely paralyzed. You cannot confidently remain in the U.S. without a rapid sponsor, and you are terrified to cross the border. The anxiety you see online stems from a fragile immigration system that keeps highly skilled professionals in a constant state of vulnerability. The best move you can make today is to step away from the fear-based rumors on Blind and Reddit. Rely on documented USCIS policies, not anonymous panic. Start organizing your personal paper trail. Download your current I-94 travel history. Collect your previous approval notices. Speak with a qualified attorney to map out your specific dates. Keep in mind, we break down the news, but this is not legal advice. Every worker has a different timeline and different dependent situations. You need legal counsel tailored to your life. The legal framework treats visa holders as temporary guests, but the careers, homes, and families you have built are real, and they are permanent. Knowing the mechanics of the timeline is the most effective way to protect your future.